Hello everyone, I'm Shubham Jain and today I'm going to be discussing the concepts of defamation, malicious prosecution and nervous shock. Without wasting any time, let us directly go to the first concept for the day, that is defamation. Every person has a right to reputation, and this right to reputation also includes the right that this reputation must not be hurt. It's a right in rem, which means कि ये right पूरे world के against valid है. Now we also understand that people have a fundamental right to freedom of speech, which is enshrined under Article 19(1)(a). But this freedom of speech is restricted by reasonable restrictions, and defamation is one of such restrictions. It's important to understand that defamation can have two aspects. One is civil and other one is criminal. It is recognized under Section 499 of the Indian Penal Code, and under civil law, it is governed by the law of torts. Defamation can take two forms. One is written, that is libel, and other one is spoken or verbal, which is slander. In order to prove that a tort is libelous, you need to prove four aspects. First one is that the statement must be false. Second one is it must be in writing, because libel is in the form of writing. The third one is that the statement must be defamatory. And the fourth one is that the statement must be published. We'll discuss all of this in detail. The first necessity is that the statement must be false. And there's a presumption in law that the statement would be false. One is not required to show any motive for the false statement. So for example, if I write a libelous statement against someone, then it will be presumed that the statement is false, and B, the plaintiff is not required to show that I wrote it with a bad motive. The second aspect of libel is that the statement must be in writing or in the form of a caricature or anything printable. So for example, if a newspaper publishes a caricature of a politician which is defamatory in nature, then the newspaper can be held liable. In order to be defamatory, it is not required that the statement must actually bring down the reputation of a person. However, if it has the potential of bringing down the reputation of a person in the eyes of reasonable members of the society, then the statement will be considered as defamatory. And while analyzing such statements, you are required to look at the entire content and not just a part of it. आप ऐसे नहीं कर सकते कि आप एक पूरे पैराग्राफ में से केवल एक लाइन उठा लें and उसको बोले कि ये defamatory statement है. You have to look at the entire context in which the statement has been spoken. Now it is also important to show that this statement is specifically in reference to the plaintiff. So कोई statement ऐसा हो सकता है कि आपका नाम specifically mention नहीं करे या फिर किसी और name से एक pseudonym से आपको refer किया जा रहा हो. But if the plaintiff is able to show that the statement refers to him, then it will be considered as a defamatory statement. Now it is also to be noted that a general statement has to be analyzed in the terms of larger society. So if you do not know about the existence of a person, but the statement would still be applicable to that person. For example, let's say a newspaper publishes a report which is about a Ram who lives in Delhi. Now another Ram who lives in Bombay files a defamation suit for that particular statement. The basis for that would be that the relatives, the neighbors of this Ram who lives in Bombay reasonably thought that this statement referred to this Ram that they know. So the reputation of Ram who lives in Bombay was hurt by this statement, and therefore newspaper can be held liable for this. Now the statements may be made in a certain manner which may not be defamatory per se, but if you analyze it in the context, it may turn out to be defamatory in the manner in which it was being said or written. Now, if the court determines, in looking at the entire context, that the statement was in fact defamatory, then the court may rule accordingly. The fourth aspect which is important to prove in case of a libel is that the statement must be published. Now, publication takes place when the defamatory statement is communicated to a third party. Now, if the defendant is aware that the statement that he is writing will be read by a third party before the intended person reads it, then it will still constitute as defamation. For example, if you're writing to a person X, and you know for a fact that his personal secretary would be reading that letter and the statement is defamatory, then it would still constitute as publication. It is important to note that any communication between husband and wife is not considered to be publication. However, if communication of a defamatory statement about the wife is made to the husband or vice versa, it would still be considered as defamation. The second form of defamation is slander. In order to establish slander, there are four elements that must be proven. First is that the statement must be false. Second is that the statement must be defamatory. The third is the statement must be published. And the fourth one for slander is that there is specific damages due to that particular statement. It is important to note that merely spoken words are not actionable until unless there is a specific damage that has taken place to the plaintiff. Now, one of the peculiar cases for slander is that when a slander is repeated, the originator of the slander can also be held liable for the repetition when it is reasonably expected that the statement will be repeated. And obviously the third person who is repeating the statement will also be held liable for defamation. Now we'll be discussing certain defenses to the tort of defamation. In all, it can be considered that there are 6 defenses to the tort of defamation. The first one being truth. If a statement hurts the reputation of another person but it was true, then the statement won't be defamatory. The second defense is that the statement was said in a bona fide manner in a larger public interest. In such a scenario, it is important that the public at large must be interested in that particular statement. It must cater to something which relates to public at large. The third defense is a privileged communication. For example, if a speech is made in the parliament which may be defamatory, it would still not be considered as defamation. Secondly, communication between a husband and wife is also a privileged communication. The fourth defense is consent. That is, जिसके अगेंस्ट आपने defamatory statement बोला है, उसने consent दिया था वो statement publish करने के लिए. The fifth defense is apology. If you have said a defamatory statement, simply apologize. That can prevent us from being upheld in the court. The sixth defense is amends. You have to publish the correct statements again, along with an apology of publishing the wrong information prior to that. The second aspect of amends is that an agreeable amount can be paid to the aggrieved party. And if they institute a suit, then you can insist on upholding the earlier agreement between the parties. Those were the defenses to the tort of defamation. The next thing that we'll be talking about is the tort of malicious prosecution. Now, malicious prosecution is a tort wherein a person files a complaint against you, files a suit against you with the intention of misusing the proceedings of the court in order to hurt you. In order to establish the tort of malicious prosecution, following elements must be established. Firstly, you have to establish that you were in fact sued by the defendant. Secondly, you have to establish that the proceedings were started without any probable cause or justification. Thirdly, you have to establish bad intentions on the part of the defendant. That is, the suit was aimed at misusing the process of law in order to hurt you. Fourthly, you have to establish that you suffered some amount of loss or damage on account of those proceedings. This damage could also be damage to reputation. That constitutes the tort of malicious prosecution. The third thing that we'll be discussing today is the tort of nervous shock. The law of tort also recognizes that there are certain damages which are psychiatric in nature and which may impact your mental health. And these damages also have to be accounted for. In order to establish the tort of nervous shock, one must establish that there was a duty owed to you. Secondly, that there was a breach of that duty. Thirdly, that there is a causal link between the breach of duty and the shock. Fourthly, the causal link between the shock and the breach of duty is not too remote. Now, essentially, in an accident, there can be two types of victims. That is the primary victims, the people who directly suffer from that accident. And secondly, there are people who suffer from shock due to that incident. Now, if someone directly witnesses that accident or their friend or their family member has gone through that accident and they receive a news about it, it is reasonable for them to receive a shock due to that news. So therefore, in order to determine who can be a secondary victim, one may look into the following criteria: the relationship between the plaintiff and the person suffering from that accident, proximity of the plaintiff to the accident, the means by which the plaintiff received the news, and the manner in which psychiatric illness was caused. So guys, that is it for today. I hope you really enjoyed the video and got to learn something new. Don't forget to like, share and subscribe, and also follow our Instagram page for latest updates.